Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. Look, I have a theme for us today, and the theme is, come on, baby, let's do the twist. You know the twist, don't you? Round and round and round, Chubby Checker's song and the dance craze. Okay, now don't you go thinking I've gotten all twisted up today. As I was preparing my notes for our video, I kept thinking about the Chubby Checker song, Come On Baby, Let's Do the Twist. And it is just so relevant to what we're going to talk about. Look, we started out with a simple text of the First Amendment as it appears in the Constitution. Then the court fashioned some rules for us to follow, those basic rules and principles that I explained to you in our First Amendment video. But now it looks like the court is doing the twist in terms of how it is modifying some of these basic rules. So I think you're going to agree with me after you listen to this video today that the court was doing the twist and going round and round some of the basic principles it set out. But if you don't follow that, if you don't follow me, if I've gotten it too twisted up for you, I'll tell you what you do. You go and take a listen to or watch the Chubby Checker video on YouTube. I've given you the information you need in the text box, and then you read the cases for yourself. And I can assure you that you're going to be doing the twist right along with me, and also it appears with the U.S. Supreme Court. Now, let's start with this. Well, let me go back a second. I got to say my sentence that the court has ruled in many cases interpreting the First Amendment. All explanations here are my own, and they are not to be ascribed to my school or to my students. For informational purposes, I'm a professor at Mississippi College School of Law, and I've been a professor in law or business school for about 30 years now. Okay, now, but don't get it twisted. I still got some moves. I can still do the twist, and watch me twist right along here with the court. Okay, let me tell you what I mean. So the text of the First Amendment says that the freedom of expression is protected. It is an individual right. But then the court said, let's break that down some. The court said that pure speech is protected from content regulation by the government unless the government can satisfy a very high standard of review called strict scrutiny. In other words, in order to touch the pure speech, government would have to show that it had a compelling governmental interest, right? And that the regulation on the speech is narrowly tailored to that interest. Okay, the court said that's pure speech, but pure conduct is not. It's not protected by the First Amendment. Some conduct, of course, may be protected under other constitutional provisions, but pure conduct is outside the reach of the First Amendment. Pure conduct. Pure speech, the court says, gets the highest protection. But there's another unless the court added in, unless the speech is in an unprotected category. If the speech is in an unprotected category, government can regulate it with a very low level of scrutiny. The court is not going to scrutinize it very much at all. The court says all government would have to show is that the regulation is rationally related to a legitimate governmental interest. Any legitimate governmental interest, just rationally related, doesn't have to be the wisest. So what is this speech that's in this low level? There's these unprotected categories that government may regulate more. We already said over here, you have speech advocating legal action, fighting words, defamation, obscenity. And in our last video, we added one additional category of unprotected speech, and that is under the Ferber case, certain sexual depictions of actual children, even if it is not legally obscene under the Miller test. Now, you may be saying, well, that was twisted enough already. How much more twisting can the court do? Well, get ready. This video is about the court doing the twist in terms of fighting words. Now, when you go back to the video, or as you may remember, on fighting words, the court said that fighting words are unprotected. Fighting words, government may regulate them, and the court will just do a low level of review as to whether or not the government regulation is constitutional. So what are fighting words? The court said in the Chubby case, the fighting words are the words that would cause an ordinary man to fight. And so that government has a right to regulate that. So to keep peace and to keep order and tranquility and to cut down on violence. So the test said the words that would cause an ordinary man to fight. And in class, we talked about, did they really mean an ordinary man? What about an ordinary woman? Or did they mean person? And why are we just saying ordinary? And now with the cases we're going to look at today, where the court seems to be doing the twist, the question I ask you is, what race, what ethnicity is the ordinary man? I know you may think, you can check me. I'm putting the names of these cases in the box below. So if you think my explanation of the case is not accurate, and surely the court didn't rule in that way, go read them, Google them and read them for yourself. And I'm sure you'll be doing the twist right along with me. Okay, so let me ask you this. Let's say that someone at night burned a cross, a cross like the KKK would burn, burned a cross in your fenced-in yard at night. And let's say that you are Black. It's a Black family. Would those be fighting words? Would those be words that would cause that Black family perhaps to fight or to engage in flight? And if so, if they are fighting words, then a law prohibiting them and criminalizing that conduct or speech, the court said fighting words, all you need is a rational basis, rationally related to a legitimate governmental interest. So in RAV versus St. Paul, our first case where that happened, why did the conviction get reversed by the Supreme Court? So in RAV versus St. Paul had a law, and their law banned certain things like burning crosses in individual shards, swastikas, and other types of hate speech. So this young white man, he burned a cross. There may have been several of them. They burned a cross in the fenced-in yard of a Black family. So why didn't the court uphold the conviction? Now, Justice Scalia, who is, he's passed away now, was a very conservative member of the US Supreme Court. You could tell a lot that he did not take this cross burning perhaps as seriously, based on how he started out his opinion. Justice Scalia said, some teenagers in the pre-dawn hours, he didn't say at night, he said pre-dawn, he said they burned a crudely built cross made from chair legs. You know, I'm sure that the family affected still saw it as a burning KKK-like cross. But let me tell you what Justice Scalia said here. And he wrote for the majority of the court, they struck down the law and reversed the conviction of the white defendants who burned the cross. Justice Scalia said, St. Paul is discriminating. St. Paul is discriminating in regulating hate speech. Some hate speech, St. Paul is banning or criminalizing, and some hate speech, it is not. So therefore, because it is discriminating, the law is invalid, and any convictions under this law would not stand. Now, some of the justices said, now hold up, wait a minute, that's twisting what was said about fighting words. These are fighting words, and fighting words, a state, a city can regulate them with just a low-level rational basis. So you're twisting up things. Now, interestingly, the majority, not just the majority, all of them on the court did have some problem with the way the law was framed. Several of the other justices said, don't create a new rule here. The law is maybe overbroad, or maybe the law is under-inclusive. Let's use the terminology we already have, instead of saying that fighting words, you cannot regulate fighting words in a discriminatory way or in a way that does not address all of the fighting words or what have you. So regardless, we have this RAV versus St. Paul case and Justice Scalia's opinion. So our rule was that pure speech is protected unless government can satisfy the highest level of review. Unprotected speech, like fighting words, all government has to show is a rational basis level review, but we got the twist. But see, RAV versus St. Paul. And what does it stand for? What does it stand for long term? Even just some of the other justices were confused about that and confused about what the case was doing. I think that maybe one thing it did, it may have made some cities and some states a little bit more hesitant about what to do in terms of banning KKK cross burnings and other types of speech. But look, that was not the end of the twist. Here comes another twist. So Wisconsin versus Mitchell, a 1993 case, I give you the site at the bottom, or at least I give you the name and the date so you can Google it. Now, this is another hate crime case, but in this case, the defendant is Black and the Black defendant selects a white victim based on the victim's race, based on the victim being white. And we have a statute. Now, based on RAV versus St. Paul, you would think the court would have held the conviction of the Black defendant will not stand for the reasons that Justice Scalia stated in that opinion. But no, the court did the twist. The court said, oh, this situation with the white victim is different. The court said, surely Wisconsin, under this low level, can add in an enhancement on a sentence for this kind of conduct. And this is conduct in terms of the hate directed toward the white victim. And so therefore the court upheld the conviction of the Black defendant. So we have RAV versus St. Paul, giving government pause, how can they deal with hate speech? Then we have Wisconsin versus Mitchell, where with this particular victim and defendant, the court said, this is okay. So you know what's coming, get ready, another twist. So let me go back. The Wisconsin versus Mitchell opinion was written by Justice Rehnquist, who has also passed away. So we have Justice Scalia, Justice Rehnquist. Now, Justice Scalia and Justice Rehnquist are two of the more conservative justices on the court. Let me pause for 1 second. Okay, I'm back. Now, Justice Scalia and Justice Rehnquist are were two of the more conservative justices on the court. But another very conservative justice on the court is Justice Clarence Thomas. I'm sure you've heard of him. Justice Clarence Thomas is currently the only Black justice on the United States Supreme Court. He took the seat of Justice Thurgood Marshall after he resigned from the court. Now retired from the court. Now, Justice Clarence Thomas is usually sides with Justice Scalia and Justice Rehnquist in the opinions that he writes. But he came out with a different twist in a case called Virginia versus Black. And Justice Thomas during that time tended not to say very much in oral argument when the attorneys would come before the Supreme Court to argue the case on appeal. And he tended to be a rather quiet justice. However, in this case, Virginia versus Black, Justice Thomas spoke up. He questioned the attorneys. Some people say he was even shaking. And when he wrote his opinion, he was the only justice that fully embraced his view. He read it from the bench with great passion and conviction. And you may say, what got Justice Thomas into doing the twist? Virginia versus Black. Now, Virginia versus Black was about cross burning again. And what happened in this case, we had two different situations with cross burnings in Virginia, and they were consolidated for the Supreme Court appeal. So in one situation, this is what happened. In one situation, Barry Black and others. Now, Barry Black, his last name is Black, but he is white. Barry Black and others, they had a rally beside the highway. The rally actually was on private property with the permission of the person who owned the property. They weren't right off the highway, but you could see some of the activities as you were driving along the highway in Virginia. So they had a rally, and as a part of their rally, they had a KKK cross and burned the cross. And there were some individuals there who gave speeches. And in one of the speeches, one of the individuals said some things like he wanted to take a gun and go out and kill Black people. Okay, so that's one rally. The rally, the cross burning on private property, but with permission of the property owner. And there were some remarks made. Some individuals who observed what was going on or who was driving down the street, they said these words made them very afraid, and they feared that there was going to be a fight, or they feared that they were in danger. So it sounds like this could constitute fighting words, okay? Now, there was another cross burning in a separate case. In that case, two young white men, they burned a cross in the yard of a Black family. They were apparently annoyed with them for some reason. The Black family had, well, they say they were annoyed for some reason. They say it was just a prank. But when the Black family who were new to the neighborhood saw that cross burning in their yard, they said they were in terror. They were afraid and thought they were going to have to fight. Now, doesn't that sound like fighting words? Would it cause an ordinary person to fight? It did cause this Black family to fear they would have to fight or flee. So we have these two different cross burnings in Virginia, and the court consolidated them together for the appeal. Now, the Virginia law is what gave the court pause. The Virginia law said that cross burning is unprotected speech, cross burning is a crime, cross burning is fighting words if it is done with the intent to intimidate. Cross burning done with the intent to intimidate. So now you see the two different cases we talked about and how the court may have struggled. One, a rally on property with permission, the other done in the yard of a Black family new to the neighborhood based on the defendant's upset or whatever they said they had toward the Black family. So we had these two kind of different, in a way, different cross burnings. So the court says, well, first of all, cross burning done with the intent to intimidate, the court said that is unprotected speech. That's fighting words. The court said that. Now, not all of the justices agreed because of RAV versus St. Paul. They said the court is getting it twisted again. But the majority said cross burning done with the intent to intimidate is indeed unprotected speech and fighting words that the government has a right to regulate with a low standard, rationally related to a legitimate governmental interest. You're like, so what's the problem? We know that the cross burned in the Black family short. We know the other one will have to look more in terms of whether or not it was done with the intent to intimidate others. Well, there were some model jury instructions, and this case had a lot of procedural things going on, these two cases. But the jury instructions said that if there is a cross burning, you can presume that it's done to intimidate. If there's a cross burning, you presume that it's done to intimidate, or there's a prima facie case that it is done to intimidate. But then the defendant can come back and say, oh no, I didn't do that to intimidate individuals. We were just having a rally celebrating history. We didn't even know that other people could see it. They could say things like that. The majority said that since there was this presumption that a cross burning was bad, the conviction of the defendant, Barry Black, who burned the cross in the private property with permission and people could see it going down the highway, the court struck down that conviction. No. As to that cross burning. As to the cross burning of the two individuals who burned without permission in the yard, the two white young men who burned it without permission in the yard of the Black family, the court said, we're going to send it back to the lower court. We're sending it back. If it was done with the intent to intimidate, then the convictions would stand. And it was sent back down to the lower court as to the burning in the yard of the Black family, and the convictions were upheld, and those two individuals did serve a sentence for that cross burning done with the intent to intimidate. Now, you're like, wow, you're ready to go hear Chubby Checker by now, right? But what I wanted to point you to was Justice Clarence Thomas's dissent. Now, ordinarily, he votes with the more conservative members of the court. But this time he said, hold up now, there is nothing wrong with this law. If the person did not intend to intimidate, they can still introduce evidence to the contrary. He also said, it's something he said at the very beginning of his opinion. At the very beginning of his opinion, he said something like this: there are some things that outsiders will never understand. And then he started to talk about the history of the KKK in America, and the history of cross burning, and the history of Virginia. And he said, just think, Virginia at one point had such segregation, but the state of Virginia wants to end the cross burnings in their state done with intent to intimidate. And so here he was saying the rest of the justices don't get it. They don't get it. He was suggesting that they do not understand the fear and terror that some people may have when they see a cross burning. So what do you think? Do you think that from RAV versus St. Paul to Wisconsin versus Mitchell to Virginia versus Black, do you think that this concept of what are and what are not fighting words, do you think that it's become twisted? I mean, what do these cases stand for? I mean, I think we still say that fighting words is an unprotected category that government can regulate with a low-level review. But you may have to deal with RAV versus St. Paul. You may be able to use a hate offense, the nature of the offense, to enhance a sentence. And under Virginia versus Black, we now know from the court that cross burning done with the intent to intimidate is fighting words. But Justice Thomas makes an interesting point here. Fighting words said, what would cause an ordinary man to fight? And he said, there are some things that outsiders do not understand. And I think the implication is, if you've never been afraid of a cross burning, maybe you don't know the fear, the fight or flight response that may result. So regardless, we have these opinions for you to think about. Play that Chubby Checker music and take a look at these cases for yourself. Remember, the Constitution says we the people, in order to establish justice. Learning takes us on the path to enlightenment, and enlightenment takes us on the path to justice, or at least to a taste of justice. I'll see you at my next clip. We're going to still be doing the twist. Okay, thank you. See you next time. Bye-bye.